The call came in at 8:47 on a Tuesday morning. I remember the exact time because I was still in my car in the parking lot of the hospital where I work, finishing the last of my coffee before a 12-hour shift. My phone buzzed on the passenger seat. The number was local, but I didn't recognize it. "Is this Claire Donovan?" a woman asked. I said, "Yes. This is Sandra Holt at Meridian Title and Escrow. I'm calling to confirm your authorization on the pending sale of 4219 Whitmore Lane, Glendale. We have a closing scheduled for this Friday, and we need verbal confirmation from you as the estate representative before we can proceed." I set my coffee in the cup holder very carefully. "I'm sorry," I said. "What sale?" There was a pause on her end. "The sale of the property at 4219 Whitmore Lane," she repeated. "The listing went active 3 weeks ago. We're 4 days from closing. The buyer has already completed inspection." I knew that address. That was my mother's house. My mother had been dead for 11 weeks. "I never authorized a sale," I said. Sandra Holt went quiet. My mother passed on a Sunday in October, quietly, in her own bedroom, with her cat on the bed beside her and a cup of chamomile tea on the nightstand that had gone cold hours before I arrived. She was 67. She had a small savings account, a paid-off car, and the house on Whitmore Lane, where she had lived for 22 years. She had a will. I had read it with the estate attorney in September, 2 months before she died, when her doctors told us we were looking at weeks rather than months. The will was simple. My mother left everything to me. My brother was not in the will. That was not a mistake. My mother and my brother had been estranged for 6 years, since the incident with the money she lent him that he never repaid and then denied borrowing. Since the holiday dinner where his wife told my mother she was emotionally exhausting. Since the afternoon my mother called me crying and said she didn't want to talk about it anymore, she just wanted to move on. They spoke occasionally after that, birthday texts, a phone call at Christmas, but the relationship never healed. My mother made her decisions clearly and with full mental capacity, and her attorney had documentation to prove it. When she died, my brother showed up at the house 3 days later. I had called him myself, because he was her son, and whatever else had happened, she was gone, and I believed in doing the right thing. He cried in the doorway. His wife stood behind him with her hands folded and said how sorry she was. I let them inside. I showed them where things were. My brother asked, quietly, if we could talk about the estate. I told him there wasn't much to discuss, that our mother had been clear in her wishes, that I would make sure her belongings were handled with respect. He nodded. He said he understood. I believed him. That was my mistake. I sat in my car in the hospital parking lot for 23 minutes after Sandra Holt told me she would need to put the closing on hold pending clarification. I asked her not to proceed with anything. She said she would flag the file immediately. I told her I would call her back within the hour. Then I hung up and stared at the dashboard and thought about my brother's face in the doorway of my mother's house and how convincingly he had cried. I called the estate attorney first. His assistant told me he was in court until noon, but that she would get a message to him and have him call me as soon as possible. I asked her to mark it urgent. Then I drove to the title company instead of going into work. I called the charge nurse and told her I had a family emergency. She told me to take care of it and not to worry. Meridian Title and Escrow was on the second floor of a building off Central Avenue, between a dentist's office and a tax preparation service. Sandra Holt met me in the waiting area. She was a woman in her 50s with reading glasses pushed up on her head and a look on her face that I recognized from the few times in my life when someone has had to tell me something difficult and didn't quite know how to begin. She brought me to her office. She closed the door. She opened a manila folder on her desk and turned it toward me. "This is the quitclaim deed filed with the county recorder's office 4 weeks ago," she said. "It transfers ownership of the property at 4219 Whitmore Lane from the estate of Margaret Donovan to Daniel Donovan as the surviving family representative." I looked at the document. My name was on it. My signature was on it. I had never signed it. I have a particular way of signing my name. Most people do. My signature has a long loop on the C, and the letters get progressively smaller toward the end. The signature on that document had the same general shape, but it was too neat, too deliberate. My actual signature is fast because I write fast. Whoever had signed my name had been trying to replicate it rather than simply produce it, and the difference was visible if you knew what to look for. "I didn't sign this," I said. Sandra didn't look surprised. She pulled out a second sheet. "This is the notarization. The notary stamp belongs to a licensed notary in Arizona. Her commission number checked out when we ran it initially, but when I pulled the document this morning to prepare for the verbal confirmation call, I noticed the commission expiration date on the stamp is listed as March of last year. She paused. The document is dated 6 weeks ago. The notary stamp was expired. Someone had used a real notary's seal number, but had either fabricated the stamp or obtained it fraudulently, and they hadn't checked or hadn't cared that the commission had lapsed. My brother filed this, I said. It wasn't a question. The filing was submitted by Daniel Donovan, Sandra said. He also signed the listing agreement with the real estate agent as the property owner. I asked her how far along the sale was. The buyer's offer was accepted at $342,000, she said. They completed inspection 2 weeks ago. We were 4 days from closing. The funds would have gone into an account that Daniel Donovan opened in the name of the estate. $342,000. My mother's house. The house where I grew up. The house where she had kept my school photos on the refrigerator until the day she died. I asked Sandra if she had a number for the real estate agent who had listed the property. She wrote it on a notepad and slid it across the desk. Then she asked me, carefully, if I was going to be contacting law enforcement. I told her yes. Good, she said. And then she said something I didn't expect. I want to help. Whatever documentation you need from us, the filing records, the timeline, the communication logs, I'll prepare it for your attorney. This isn't the first time I've seen something like this. And every time, it was family. I sat with that for a moment. Then I thanked her and asked if I could use her conference room to make some calls. The estate attorney called me back at 11:45. I explained what I had found. He was quiet for a long moment, and then he said, with measured precision, that my brother had committed forgery, filing of a fraudulent deed, and attempted grand larceny, and that we needed to move quickly. He told me to go to the police department and file a report before the end of the day. He told me to document everything and not to contact my brother directly. Then he asked if I was all right. I told him I was fine. I told him I just wanted to handle it correctly. The detective who took my report at the Glendale Police Department was a woman named Rivera. She listened without interrupting while I laid out the timeline. My mother's death, the will, my brother's appearance at the house, the call from the title company that morning, what Sandra Holt had shown me. I had the photographs I had taken of the documents on my phone. Detective Rivera looked at them carefully. The notary commission, she said. Expired 14 months ago, I said. She wrote something in her notebook. Did your brother have access to any of your personal documents? Anything with your signature on it? I thought about that. I thought about what I had let him take from my mother's house. I had given him a box of photographs, some books, a ceramic bowl our mother had made in a pottery class. I had not given him any paperwork. But I thought about the estate documents that had been spread across my mother's kitchen table during the weeks after her passing, the will, the inventory forms, the letters I had signed authorizing various accounts to be closed. My brother had been in that house. He had been alone in rooms. Possibly, I said. Detective Rivera nodded slowly. We'll need to talk to the notary, whose stamp was used. If her commission expired and she didn't produce this document, someone obtained her seal information and fabricated the stamp. That's an additional charge. She looked at her notes. Do you have any reason to believe your sister-in-law was involved? I thought about the way my brother's wife had stood in the doorway with her hands folded, the way she had watched the whole house with a particular kind of attention that I had interpreted as grief, but now understood differently. Yes, I said. I think she knew. Over the next 72 hours, the following things happened. The title company formally withdrew from the transaction and notified the buyer that the sale could not proceed due to a legal dispute over ownership. The buyer's agent was understandably unhappy. That was not my problem. The estate attorney filed an emergency motion with the probate court to confirm my sole authority over my mother's estate and to flag the fraudulent deed in the county records. The court issued a temporary order within 48 hours. Detective Rivera and her partner drove to my brother's house on Thursday morning. He was at work. His wife was home. According to what Detective Rivera told me later, when she showed my sister-in-law the expired notary stamp on the document, my sister-in-law's face went through several distinct expressions before settling on the one people wear when they realize the thing they thought was airtight has a hole in it. My brother was arrested Thursday afternoon at the accounting firm where he worked. His wife was arrested the same day. The charges were forgery, filing a false public record, and attempted grand larceny in the first degree. Grand larceny in the first degree in California, where we live, applies to theft of property valued at more than $950,000, but the attempted theft of $342,000 qualified under related statutes and carried serious weight. I found out about the arrest from Detective Rivera, who called me at 6 in the evening on Thursday while I was making dinner. I set down the spatula and stood very still in my kitchen. It's done? I asked. They're both in custody, she said. Bail hearing is tomorrow morning. I thanked her. After we hung up, I sat down at my kitchen table and I thought about my mother. I thought about her 22 years in that house. I thought about how she had made her decisions clearly, how she had drawn her boundaries, how she had done everything right, and how her son had stood in her doorway and cried and then spent the weeks after her death trying to steal the home she had left to her daughter. I thought about that for a while. Then I got up and finished making dinner. My brother and his wife hired attorneys. The case took 9 months to move through the system. My brother pled guilty to 1 count of filing a false public record and 1 count of attempted grand larceny. He was sentenced to 3 years of probation, 200 hours of community service, and full restitution of legal fees, mine and the title company's. His wife pled guilty to a misdemeanor charge of accessory to filing a false public record. She received 18 months of probation. It was not the sentence I would have written if I had been the judge. But the prosecutor explained to me that first-time offenders with no prior record and with attorneys who negotiate well tend to avoid prison time in cases that did not result in completed theft. The crime was caught before the money changed hands. That mattered to the court, even if it didn't fully satisfy me. What I know is this: the record exists. The conviction exists. The plea is on file. My brother cannot practice in any role involving fiduciary responsibility. His employer terminated him before the case went to court. The accounting firm where he had worked for 11 years let him go the same week he was arrested. I sold my mother's house 7 months after the probate court issued its final order. I chose my own realtor, set my own price, and closed on my own terms. The buyer was a young couple with a toddler who had been looking in that neighborhood for almost a year. When I handed over the keys, the woman said the house had good energy. I told her I thought so too. The money is in an account that only I can access. I have spoken to a financial advisor. I have a plan. My mother worked her entire life for what she left behind, and I intend to respect that. My brother has not contacted me since the arrest. His wife sent me a text message 3 weeks after they were charged. It said, "I hope you know what you've done to this family." I read it twice. Then I deleted it without responding, because there was nothing in it that deserved one. There are people who will tell you that family comes first. I have heard that phrase my entire life. My father used to say it. My mother used to say it, though she meant something gentler by it. My brother said it too, in a different context, years before any of this happened. What I understand now and what I understood, I think, in some quiet place even before Sandra Holt called me, is that the phrase only means something when it goes both ways. When one person treats family as a resource to be extracted rather than a relationship to be honored, the obligation does not survive that. My mother knew this. That is why she wrote the will she wrote. I kept the ceramic bowl my brother had returned when he took his box of photographs. It sits on my kitchen counter. It is pale blue with an uneven rim where my mother's hand slipped slightly on the wheel. She had told me, laughing, that it was a failed piece, that she was going to throw it out. I told her I wanted it. It holds my keys now. Every morning when I leave for work, I reach past it and think about her. That is what she left me. The house and the savings were part of it, but the bowl was always the thing that mattered. Before any of this happened, I would have told you I trusted my instincts about people. I would have told you I knew my brother well enough to understand what he was capable of. I was wrong about that, and I have had to sit with that wrongness and figure out what to do with it. What I did with it was this. I became careful. Not suspicious of everyone. Not closed off or brittle, but careful. I read documents before I signed them now. I call the number on the letter to confirm it's real before I give any information. I notice when someone asks questions that are slightly adjacent to the question they actually want answered. I notice when someone cries at the right moment. These are small adjustments. They cost me almost nothing, and they are the reason that when Sandra Holt called on a Tuesday morning and asked me to confirm the sale of my mother's house, my first response was not confusion or assumption of error. My first response was to set my coffee down carefully and pay close attention. If you are listening to this, and you are in the middle of handling an estate, or you are the beneficiary of something, a policy, a trust, an account, a property, please hear me when I say this. Check the records yourself. Don't assume the paperwork is in order because you haven't heard otherwise. County recorder offices are public. Title companies will talk to you. The estate attorney you pay is working for you, and you can call them. And if someone in your family has access to documents with your signature on them, pay attention to that. Not because family is the enemy, but because the people who hurt us most are usually the ones we let closest. I still drive past Whitmore Lane sometimes. Not often, and not on purpose. It's between the hospital and the grocery store I like. And sometimes the timing works out that way. The new family put up a small basketball hoop in the driveway. There are shoes by the front door. Last time I passed, someone had planted something in the bed along the front walk that hadn't been there when my mother was alive. Something tall and bright that I couldn't identify from the car. The house looks like it has people in it again. That is the right ending for it. My mother would have agreed.